Good day, ladies and gentlemen. Thank you very much once again for following our series on company issues. This time, we are going to speak about resignation and the removal of a director from a company. I am Sukhdev Kaur from Law Chambers of Sukhdev. I am an advocate and solicitor of the High Court of Malaya at Kuala Lumpur. And together with me is Jeannie Seelan.
Good afternoon, everyone. I'm Shivaji Seelan from JS Partners. I'm an accountant and we focus on corporate affairs and corporate matters.
Together, we will be discussing some of the issues and procedures in respect of resignation and removal of a director from a company. Ladies and gentlemen, before we begin, we'd just like to advise you that the issues and matters that are discussed in this video are information for the public, and it is not to be construed as legal advice. Any legal advice that you may seek or you may want, you can always get in touch with me or Jeannie, and we'll be happy to assist you accordingly. Okay, so Jeannie, today we have a very interesting topic to discuss. Shall we start with the difference between a designated director and a statutory director?
Okay, sure. A designated director would be a director who is given the role as a director in a company, but he or she may not be in the board of directors or in the statutory books as a director. So it's just a title given for the job that they may use the term director. So a statutory will, of course, be a director who is in the books of the SSM records, and he basically would be responsible with the acts of filing the documents and accounts in, and he has all his statutory rights.
Okay, can you explain the resignation process for the designated director and the statutory director?
Okay, for a designated director would be, of course, following the Employment Act, he would just have to pass a notice of resignation to his employer. When it comes to a statutory director, he, in order to pass, it's under Section 208 of the Companies Act, and he would have to give a written notice of his resignation to the company secretary that he would want to resign, and a copy, of course, to the board of directors.
Okay. Now, moving on, we'd like to discuss about the removal of a director. But can you explain what is the difference between resignation of a director and removal of a director?
Okay, a resignation is basically his consent and he's willing to resign accordance to his own will. And he basically, sends a written notice quite easily to, the necessary secretary and the board of directors. However, a removal is when he refuses to resign. And he doesn't want to resign as a director, and he has now moved toward a removal of director because the rest of the board of directors want him out.
I see. Okay, but now that we can actually incorporate a company with just one director, right? What happens if that single director, and he's also a single shareholder of the company, passes away?
Okay, so in the event a director passes away or becomes an unsound mind, the company secretary would be able to call for a meeting of the next of kin or the other representatives to appoint a new director.
Now, like you have explained, that it's not only in a situation where the sole director has passed away upon his death, but it's also by reason of his mental incapacity. Then,
yes.
And in accordance to the Mental Health Act 2001, so that his estate may manage his appoint a person as a director. Sorry. Okay, and so in this circumstance where there's just a single director or last remaining director, the process of the procedures of removal of directors that is discussed at Section 206 becomes impracticable, isn't it?
That's right. Exactly. That's right. Because he may be the director, the sole director, and he is also the sole shareholder. So, he won't be able to remove himself. So it won't be, practical in this sense.
Well, I suppose the alternative to that is for him to voluntarily wind up his company.
Yeah, so I mean, if he really doesn't want his company, then the option is, of course, to wind up the company, and he can basically strike it off.
Okay, all right. So let's come back to the procedures of removal of directors, which is provided by Section 206 of the Companies Act 2016.
Yes. Okay. So in order to remove a director, basically a director will be removed by an ordinary resolution. Okay, and it would need to be passed by a physical general meeting. Okay, and a notice would have to be given for, a period of 28 days. Yeah, and to the particular director, and to his last known address.
Okay, let's go through that again. Section 206 here is applicable to both the private company and the public company. So when you spoke about the special notice with 28 days to be given, is this applicable to both the private company and the public company, or either one?
With this new act, it is applicable to both the private and the public.
Okay, and to his last, to be served at his last known registered address, right?
That's right.
So what happens if, how do you prove that it was served at his last known registered address?
Okay, well, the procedure is basically, we would serve the notice at the address that has been registered with us, and this could be, by registered post or by our dispatch, who can actually give us an acknowledgement. And registered post, of course, if the post is failed, then we would get a notice to say that this is, this person is not there. However, the law states that it has to be in the last known address. Now, it's his responsibility as a director or shareholder to inform the company secretary of the changes of his residential address.
All right. Now, moving on, after the notice has been given, okay, and the director has come to know about the resolution for the removal to be held, okay, what is the next course of action available for this director?
Okay, so once he received the notice, he'll be able to basically do an oral representation or a written representation regarding the resolution that has been passed with reference to his removal. And he can also say that he wants it read at the special meeting.
Under Section 322 sub 4, it says that if it is not practicable to give such notice of 28 days, then you just have to give a notice for 14 days. So what sort of circumstances would it be not practicable to give that 28 days notice?
Okay, so the reason why sometimes it might not be practical is because most of the time it's always in a hurry. Now the reason being is the director might have taken money out of the company. It might have been a fraud. He might be issuing unnecessary checks, or it could be many of these kind of reasons that will cause the situation to that it can't we can't wait for him to basically wait for the 28 days, or he refuses to sign the audited accounts.
All right. Okay. So what is the garden leave?
So the garden leave would be someone who has basically given a leave to stay away from the operations or the office, but he will be still remunerated. And the reason why this is given sometimes is to avoid Anyone from, the person has been messing up the books or has been causing some, maybe ill feelings between the relationships that are happening in the business, and it might be better for him to take a break. This is why garden leave sometimes is given.
Let's come to damages.
Mm-hmm.
How will the director who's removed be paid damages? Is he entitled for damages? Is he entitled for remuneration pending the amicable settlement? When will the removal take effect in order for remuneration to be calculated or damages to be calculated?
Okay, so it will all depend on the situation, but usually by the time it reaches removal, it's always very bitter, the relationship. But just say the meeting goes on and he is, been approved to be part the resolution of the removal, then immediately, within 30 days, the submission of the relevant forms, which is the Section 58, which is the form to submit to SSM on the removal of director. And if he has shares, Section 105 will be the form to be used. Previously it was 32A, now it's 105 to be filed. Now, and then at that point, they can also calculate, if there was any amounts owing that needs to be paid to this particular director. At that point, of course, it's a discussion. If there was a contract of employment, then it'd be, of course, easier because you can just follow, what is due up to the date.
Okay. So we have come to the end of our discussion on the resignation and removal of directors. For our conclusion for today's discussion, Ginny, would you like to say something?
Well, in summary, we would always encourage the person, or speak to both the directors, or more than two, in fact, sometimes, to resign, and to hopefully they can amicably resolve the situation before it moves towards a removal procedure, because it just becomes very, very complicated and messy.
Right. So with that, we end our session today, and we hope to bring you more discussions in our next series.
Okay, yeah, take care. I hope the information has been very useful as well. And do contact us if you require any information or guidance. And stay safe and take care.